Welcome back to the Deep Dive. Today we're talking about something that sounds a bit like science fiction for inventors, a kind of legal time machine for your patent application.
Huh. A time machine. I like that. Yeah, is this idea that you can effectively shield your invention by reaching back to an earlier filing date?
Exactly. And this is all part of our ongoing series where we're building this comprehensive audio guide to the Manual of Patent Examining Procedure, the MPEP, piece by piece.
Right, tackling it section by section. Today we're diving into Chapter 200, which deals with application types, status, and crucially, benefit and priority claims.
And our specific focus is MPEP Section 211. That's the one titled Claiming the Benefit of an Earlier Filing Date under 35 U.S.C. 120 and 119E.
And our goal here is really to unpack how a later filed application can legally grab the filing date of an earlier one. It sounds technical maybe, but it's fundamental.
Fundamental how? Why is it such a big deal?
Well, it's critical for securing your priority rights. Basically, protecting your invention against things that pop up later, Dick said. Other inventions, publications, what we call prior art. We're going to break down the what, the why, and importantly, the how-to.
Okay, so let's start with the basics. This claiming benefit.
Yeah.
What exactly does that mean in practice for someone filing a patent application? Why reach back?
It means your later application gets the effective filing date of the earlier one. And in the patent world, timing is often everything. Who filed first can determine who gets the patent.
Ah, so an earlier effective date gives you a stronger position against anything that came after that date.
Precisely. It's like drawing a line in the sand earlier in time. Anything published or invented after that line might not count against you as prior art. It's a huge defensive advantage.
Okay, makes sense. So this isn't just some loophole. There's a specific legal basis for it.
Oh, absolutely. Section 211 is built on solid statutory ground. We're mainly looking at Title 35 of the U.S. Code, Sections 119E, 120, 121, and even 365C and 386C for international stuff. And these are all supported by the regulations, specifically 37 CFR Section 1.78.
Can you give us a quick rundown of what those different U.S. Code sections cover? Like, when would you use 119E versus 120?
Sure. So 35 U.S.C. 119E is typically your go-to for claiming benefit from a provisional application, that initial sort of placeholder filing.
Okay, the provisional route.
Then you have 35 U.S.C. 120. That's more for claiming benefit from prior non-provisional applications. Think continuations, divisionals, or continuations in part, often called CIPs.
Got it. Different paths for different situations.
Exactly. And 121, 365C, 386C relate more specifically to divisionals arising from restriction requirements, international PCT applications, and international design applications, respectively. Each has its specific use case.
All right, so if you want to use this time machine, you want to claim that earlier date, what are the absolute must-haves, the non-negotiable?
Okay, there are basically 4 key requirements you absolutely have to meet for a valid claim.
4 pillars. What's number 1?
Number 1 is proper reference. The later application must specifically point back to the earlier one.
How specific?
Very specific. You generally need to include the earlier application's number, the series code and serial number, or, the international application number and filing date, if applicable.
And where does this reference go?
For non-provisional applications, this reference must be included in an application data sheet, or ADS. That's critical.
The ADS. Okay.
And you also need to state the relationship. Is it a continuation, a divisional, a CIP? That needs to be clear too. It's all about creating that clear, documented link.
Right. No ambiguity. What's the second requirement?
Second is shared inventorship. There has to be at least one inventor named in the later application who was also named in the earlier application.
So a connection between the inventors.
Exactly. There needs to be that continuity of inventorship. For foreign priority, it's similar. The U.S. and foreign applications need to name the same inventor or have at least one in common.
Does the whole inventive team need to be identical?
Not necessarily. Continuations or divisionals might have the same or fewer inventors. A CIP might even add new inventors if new matter is added, but that core link, at least one common inventor, must be there.
Okay, that makes sense. Proper reference, shared inventorship. What's next? I'm guessing timing is involved.
You guessed right. Number 3 is statutory time limits. There are strict deadlines you cannot miss.
Like what? Give us an example.
The classic example is claiming benefit of a provisional. The non-provisional application must be filed within 12 months of the provisional's filing date.
12 months, that's a hard deadline.
A very hard deadline, generally speaking. For foreign priority, it's usually 12 months from the earliest foreign filing for utility patents, or just 6 months for design patents. Miss these windows, and you typically lose the benefit claim.
Okay, deadlines are key. Proper reference, shared inventor, hit the deadline. Yeah. What's the fourth requirement? You mentioned something about disclosure earlier.
Yes, the fourth and arguably the most crucial one is adequate disclosure. This is the real substance.
Adequate disclosure. What does that entail?
It means the earlier application must properly describe and enable the invention you're claiming in the later application, according to the rules in 35 U.S.C. Section 112A.
So, written description, enablement, definiteness.
Exactly. The only part of 112A that isn't strictly required for benefit purposes is the best mode requirement. But the written description and enablement, absolutely critical.
And what if the earlier application didn't quite disclose it well enough?
Then the benefit claim fails. Simple as that. If the earlier filing doesn't provide adequate support under 112A for what you're claiming later, you don't get that earlier date for those claims. The foundation has to be solid.
Can you give an example of where this might go wrong?
Sure. Think about design patents. Let's say your parent application shows design A. Your later application, maybe a CIP, claims design B, which is similar but different. If design B wasn't adequately shown or described in that parent application, it fails the written description requirement.
So even if it's related, if it wasn't properly in the earlier document.
It can't claim the benefit of that earlier date.
Yeah.
The invention claimed later has to find its roots, its support, in that earlier disclosure.
Okay, that really highlights the importance of getting that initial disclosure right.
Right.
But, things happen. People make mistakes, deadlines get tight. What if someone misses a deadline or forgets the reference? Is it game over?
Not necessarily game over, thankfully. There are some provisions for, let's say, unintentional slip-ups. For instance, restoration of priority.
Restoration, how does that work?
If you file your non-provisional application after that 12-month provisional deadline, but within an extra 2 months, so between month 12 and month 14, you might be able to get the priority restored.
Might be able. What's the catch?
The catch is you have to show the delay was unintentional. You need to file a petition, explain why the delay happened, and pay the fees. It's not automatic.
And what if it's longer than that 2-month grace period?
It gets harder. If you're filing that petition more than 2 years late, you need a much more detailed explanation of the circumstances. There's a clarification notice about that from March 2020. For international apps, there's also a possibility under a due care standard.
Okay, so unintentional delay is key. What about just forgetting the reference?
Similar principle. If there was a delay in adding the required reference to the earlier application, it can sometimes be excused if you can show the delay wasn't deliberate. Again, requires a petition and explanation.
Good to know there are some safety nets.
There's another interesting one. Incorporation by reference for omissions. Let's say you accidentally left out a page of the description or a drawing figure when you filed.
Oh, that sounds bad.
It could be. But if your application already properly claimed benefit or priority to an earlier application, and the missing material was completely contained in that earlier document,
You can add back in.
you might be able to add it back in via amendment, relying on that earlier disclosure. It's a neat way the benefit claim itself can help fix an omission, but only if the info was fully present in the priority document.
That's a really practical benefit. Now, things change in patent law. What about the American Invents Act, the AIA? Did that impact these rules?
Oh, hugely. The AIA introduced major changes, and the key date you need to know is March 16th, 2013.
The AIA transition date. Why is that so important here?
Because it determines whether pre-AIA law or AIA law applies to your claims. And if your application straddles that date, meaning it has claims with effective filing dates both before and after March 16th, 2013.
Uh-oh, complications.
Potentially, yes. You need to be really careful. Applicants might even need to file a statement with the U.S.PTO pointing this out so the examiner applies the right law to the right claims. It affects how prior art is treated.
How did the AIA change the prior art rules in relation to benefit claims?
This is a really important shift. Under the AIA, certain disclosures that might have been prior art before aren't considered prior art at all under specific conditions.
Like what?
Think about disclosures made under a joint research agreement, or where the invention and the disclosure share common ownership or an obligation to assign. If that relationship existed on or before the effective filing date of your claimed invention,
Then that related disclosure doesn't count against you.
under AIA sections 102B2C and 102C, generally no, it's carved out as an exception. It's different from pre-AIA law, where similar subject matter might still have been prior art, even if it didn't prevent patenting under obviousness rules. The AIA gives more protection for collaborative work, essentially.
Interesting distinction. What about international applications? Any special hurdles there for claiming benefit?
Yes, a few extra things to keep in mind. For claiming priority to foreign applications, you often need to submit a certified copy of that foreign application.
A certified copy from the Foreign Patent Office.
Usually, yes, and if it's not in English, you'll need an accurate translation. There is a provision for submitting an interim copy sometimes, which can satisfy the requirement temporarily if it's clearly labeled.
Okay.
And remember that interaction with prior art dates. For certain PCT applications filed after late 2000, published in English, and designating the U.S., the international filing date itself could serve as a U.S. prior art date under pre-AIA 102E, but only if the disclosure met the 112A requirements back then.
It seems like these benefit claims touch on so many other parts of patent law.
They really do. Another big one is double patenting.
Right, getting two patents for the same thing.
Yeah.
How does benefit claiming intersect with that?
Well, when you file continuations or divisionals claiming benefit, you're often refining or carving out related inventions from the same parent disclosure. This naturally raises the question of whether the claims in the later application are patentably distinct from the earlier one.
So the examiner might issue a double patenting rejection.
Exactly, especially a non-statutory or obviousness type double patenting rejection. The doctrine basically prevents an inventor from unfairly extending their patent term by getting multiple patents on the same invention or obvious variations.
Makes sense from a public policy view.
It does. It prevents multiple suits on essentially the same technology. These rejections can often be overcome, maybe by arguing the claims are distinct, or sometimes by filing what's called a terminal disclaimer, linking the expiration dates if there's common ownership.
Okay, so managing benefit claims also means keeping an eye on potential double patenting issues.
Definitely. Examiners will issue provisional rejections if they see co-pending applications with overlapping inventorship or ownership that seem too similar. It's all interconnected.
Wow. We've really unpacked a lot today around MPEP Section 211, from that core idea, the time machine, to the absolute requirements like reference, inventors, deadlines, and that crucial adequate disclosure.
Right. And not forgetting the exceptions, the rescue provisions for unintentional delays, and the significant impact of the AIA transition date.
It's crystal clear that knowing how to properly claim benefit isn't just ticking a box on a form. It's a fundamental strategic tool for protecting an invention over the long haul.
Absolutely. It's the mechanism that ensures continuity, protects rights against intervening art, and frankly helps examiners do their job properly by defining the relevant prior art landscape based on the correct effective filing date.
And just a reminder to you, our listener, this deep dive is just one part of our larger project, building a full audio guide to the MPEP, section by section, to make these complex rules more understandable. So as you think about everything we've covered today, here's something to mull over. How can what seems like a simple administrative step, correctly referencing an earlier filing, ultimately determine the entire value and strength of a patent, potentially for decades?
And please remember, while we aim to be informative, this summary was prepared with AI assistance and is for educational purposes only. It is not a substitute for legal advice. Always consult the official MPEP text, a qualified instructor, or a registered patent practitioner for guidance on specific situations.
A special thank you, as always, to Mike Shepard, the creative director who masterminded this entire audio series.